afternoon and welcome. We're going to give folks just another minute to join and get started here soon. So just hold on shortly. And if you're seeking CLE credit for today's event, please note that CLE passwords will be announced twice during this session, once at the beginning and once before the Q&A session. So please write down those passwords and enter them on the survey after the webinar. Survey is mandatory to receive the CLE credits. These passwords will tell us that you attended.
Hello, everyone. Happy Thursday, and welcome to the ACLU of Pennsylvania's all membership webinar. My name is Riley Ross. My pronouns are he and him, and I'm a partner with the law firm Minty Fitzpatrick Ross here in Philadelphia, and I proudly serve as the ACLU-PA State Board Vice President. I want to start by thanking you all for being with us today. The work to advance civil liberties takes all of us, staff, volunteers, clients, community partners, and supporters who are all dedicated to fighting for a Pennsylvania that is better for all of us. We appreciate all that you do to advance our work. One of the things that is important to us here at the ACLU of Pennsylvania is increasing the diversity of our stakeholders, every aspect of our organization, including membership, so that it reflects the world that we live in. With our webinars, there's often a broad range of folks who call in. Some of you have been supporting our work for decades, and some of you are newer to our work. We are delighted to have all of you join us today. And if you're new to our work, I encourage you to find ways to plug in. We'd like to take a few minutes to provide a brief overview or broad overview of our organization and the work that we do, especially for those newer to the organization. To that end, the American Civil Liberties Union is a national nonpartisan organization founded over 100 years ago. We do not endorse candidates for office. Here in Pennsylvania, we have a staff of roughly 40 with offices in Philadelphia, Pittsburgh, and Harrisburg, and have over 30,000 active members across the state. Our priority areas are three: one, decarceration; two, police reform; and three, voting rights. Although 70 to 80% of our work will be geared towards those top priority issue areas, the rest of our time is designed for us to remain nimble and to be able to respond to other emerging threats like reproductive rights, LGBTQIA+ equality, and other issues. All of our work incorporates authentic belonging, inclusion, diversity, and equity in a constant racial justice lens. Today, I'm excited to guide us through the ACLU of Pennsylvania's legal year in review, and we have been busy. We will hear from a few staff who I've invited to join the stage shortly. But first, a few logistics. I'll be guiding us through this dialogue with our panelists. We'll spend about 40 minutes to discuss what we've been up to this year, and then we'll leave some space and time for Q&A at the end. As an FYI, the webinar is recorded, so we are being recorded. We will plan on posting it as well, so please share the knowledge and guide others in your community towards the session. If you need closed captions, you can enable that feature at the bottom of your Zoom screen under the button that you see that says Live Transcript. We will be utilizing the Q&A function during our call, so please use it. For folks who have dialed in, you can submit your questions to us by going to email and emailing us at donate@aclupa.org. That's DONATE@aclupa.org. If you're seeking CLE credit for today's event, please note that CLE passwords will be announced twice per hour. Please write down these passwords and enter them on the survey after the webinar. The survey is mandatory to receive CLE credits, and I will give you the first of two passwords right now. That first password is civil rights. Civil rights. So go ahead and write that down. You may need to do it in all caps, so to be safe, go ahead and put it in all caps. So again, it's civil rights. And with that, I'd like to welcome our panelists. So the panelists can come on in. We have Ghadah Makoshi, Marian Schneider, and Steve Loney. Good afternoon to you all. I am so pleased to be here to help guide us through this important dialogue. Ghadah, Marian, and Steve, thank you so much for joining us and offering your expertise. So to get our conversation started today, I have a few questions for our panelists. After that, we'll open the floor up to your questions. And as a reminder, you can submit your questions at any time using the Q&A feature or emailing us at donate@aclupa.org. And panelists, I'm going to ask that the first time that you speak, that you go ahead and introduce yourself and give the audience your titles. And I want to start off by noting that it's been quite a year, right? And so I know that you've all been busy. And as you reflect on how the year has been, can you tell us what you've been most proud of? And why don't we start with you, Steve?
Thanks, Riley, and thank you to everybody who's joining us. My name is Steve Loney. I use he, him pronouns. I am the senior supervising attorney in the ACLU of Pennsylvania's legal department. For everybody's benefit, I am sitting in my office in Philadelphia. I am a white man with fair skin, short, thinning brown hair, and a very short beard. But yeah, thanks for the question, Riley. On a very general level, I'm most proud of the sheer amount of positive activity we've been able to engage with in the past year and make a real difference in a lot of different areas. Just to put some context around that, we were able to address over 1,100 incoming intake inquiries through our intake system. Those resulted in 75 active cases handled in the fiscal year, including 8 cases litigated in some manner before the Pennsylvania Supreme Court. And one recurring issue that I'm sure you'll hear from Marian about that's already gone up to the U.S. Supreme Court once and may well go up again in the coming year. In all of that work, we've had the help of 109 cooperating attorneys this fiscal year who donated somewhere around 5,600 hours of their time. That equates to about $950,000 worth of donated attorney time. So a big thank you to, especially to anybody in the audience who donated some of that time. To answer your question a little bit more directly, one case that I'm particularly proud of from this year was a great result we got for the Abortion Liberation Fund of Pennsylvania in early 2023. This was the only litigation so far that we in the Pennsylvania affiliate have done in the reproductive rights space since the Dobbs decision came down. And it was a resounding win. It goes back to 2022 when the city of Philadelphia included a $500,000 donation to the Abortion Liberation Fund as one of many donations that the city routinely makes to local nonprofits as part of its annual budget. But right after Dobbs, local anti-abortion advocates, backed by some national anti-abortion advocates, pounced and filed a lawsuit against the city and against ALF under state and federal statutes that, as a general matter, preclude use of state or federal funds to pay for abortions. But of course, those the funds in this case were purely city funds, and there's no similar statute or law stopping municipalities from allocating funds in this way. So we quickly mobilized with our co-counsel from Ballard Spahr. We defended ALF hand in hand with the city's solicitor department at an evidentiary hearing in the Philadelphia Court of Common Pleas. We got a great opinion dismissing the plaintiff's request for an injunction. And then when the plaintiffs doubled down on some abusive litigation tactics on appeal, we filed a motion for sanctions that ultimately convinced the plaintiffs to drop their appeal entirely and voluntarily. It preserved the win for ALF's ability to use that $500,000 donation at a time of great need. So that's one example of a case I'm pretty proud of.
It's awesome, Steve. Thank you. Thank you. Marian, how about you? What are you most proud of this year?
Well, thank you so much, Riley. Counsel for voting rights, and I use she, her pronouns. And for everyone's benefit, I am a white woman with medium brown curly hair. And although I'm in the office today, my background is a lovely sunset snow scene from my neighborhood. Voting rights this year, and we've had two successful pieces of litigation. One is the NAACP against Schmidt case, in which we, at the district court level, recently achieved a good ruling that Pennsylvania cannot disenfranchise voters under the materiality provision of the into that in much more detail later. So I'm going to talk about another case that I'm really excited about and proud of. In May of this year, we filed suit in Cohane, sorry, I have trouble pronouncing our client's name, against Delaware County. And that case, ballots were canceled by the county because they had a disqualifying defect on the envelope. And they instead because they couldn't get a replacement ballot in time and couldn't go to the county to cure it, they voted a provisional ballot at the polling place. Well, Delaware County, because it was relying on a Commonwealth Court unreported non-precedential decision. And the legal issue was whether the election code's prohibition to counties that they are not permitted to count ballots that have been timely received. They've ballots. If a mail ballot has been timely received, does that still apply when the mail ballot has been canceled? Well, a common sense reading says no, but we ended up filing a motion for judgment on the pleadings. And we got a great decision out of the Delaware County. The judge that was assigned, we were kind of a little worried about that, but the opinion is also a blueprint for County Board of Elections to follow. Like, what is best practice if you're going to run a notice and cure program, and how do you make sure that there's no double voting? But I have to tell you this story. We move in the voting rights space. The Board of Elections met on Tuesday. I argued why they should count these ballots. They should count these ballots. They decided not to. We have 48 hours to file our appeal. And then, so we did this with our good partners, the Public Interest Law Center of Philadelphia. But we had just had our intern starting, Steve will appreciate that. And we were getting under the deadline, really under the wire to get this filed. So we sent 3 interns to go to the clerk's office and keep them open before I could get there with the papers. And then one of them stayed outside to watch the car, and another one ran inside with me. So that was an example of teamwork, but that's how quickly we have to move in the voting rights space. So I'll stop there and we can talk more.
Thanks, Marian. Marian, I think that at least on my end, you were kind of coming in and out on a few times. So 2 things I just want to make sure or ask you to tell us. Could you give us your title with the ACLU-PA again? And then also just want to make sure that you did say that you were able to get that filing in on time at the end.
We did get the filing in on time. And my title is Senior Policy Counsel for Voting Rights at the ACLU. Yeah, my internet connection says it's unstable.
I think for the most of it, we were able to put together what we heard on each end of it going out. So hopefully we'll be able to do that for your future updates that we're going to get to you. So Ghadah, you're up next. How was your year?
Thanks for asking. So my name is Ghadah Makoshi. I am a policy and advocacy strategist at the ACLU. And for the benefit of people listening in, I'm a Middle Eastern woman with brown hair, brown curly hair, and my background is a blue ACLU background. So we've had a few successes. One success we achieved was the defeat of a proposal to expand enforcement of youth curfew in Pittsburgh. After it was proposed in January for those under the age of 17, we sent a letter highlighting our concerns with it, namely that it would harm the city's youth, particularly Black youth, while doing little to nothing to actually address crime. In response to all these concerns and criticism, they unanimously voted down the proposal. And the mayor and the other officials committed to focusing instead on launching resource centers serving youth and their families. Another area of success was in the area of summary citation, so in two particular areas. First, after several years of advocacy and speaking out about summary citations and their impact, which I will talk a little bit more about later, we reached a turning point this year where several of our partner organizations also incorporated advocacy work challenging summary citations into their ongoing work with Pittsburgh Public Schools. And all of this collaborative effort resulted in Pittsburgh Public Schools' decision in June to place a moratorium on issuing summary citations to students. Second, after many denials of requests after several years requesting summary offense data for youth, we submitted another request form and a letter to the administrative offices of the Pennsylvania courts, AOPC, in 2022. Stating in part that a blanket ban on accessing any and all information associated with these criminal cases is inconsistent with the public's First Amendment's right of access to criminal records. So after a year of back and forth, emails and meetings, the effort finally paid off, and AOPC provided us with this data a few weeks ago, so I'm looking forward to delving into that.
Thank you, Ghadah. And my apologies for those listening. I did not describe myself, but I am a 52-year-old Black male with glasses, not much hair, but that's by choice. And I am sitting at my dining room table, and in the background, there's a lovely sign that my wife created with her Cricut that says hi in big letters. So, all right. Thank you all for that input. That you've shown us that has been quite a year to be proud of. And for the audience here at the ACLU, we work day in and day out on ending the harsh policies and racial inequities in the criminal justice system. The rights guaranteed to the accused, defendants, offenders, and prisoners are fundamental political rights that protect all Americans from governmental abuse of power. These rights include the right to reasonable bail, the right to due process of the law, and the right to be free from cruel and unusual punishment. This work takes up a significant amount of time for our staff and crosses over multiple issue areas of work, like decarceration and police reform. During my tenure on the board, I have been proud of the work we've done for criminal justice, but it has never been easy. And this year has been no different. So panelists, how has the ACLU of Pennsylvania been advancing this work in 2023? Steve, we will start with you again.
Thanks. And as you said, Riley, this takes up a substantial portion of our time. There are lots of examples to pick from. I'm going to start with two examples of our work in this past year on policing. The first is ongoing work and progress made on an older case, Bailey versus City of Philadelphia, which was actually filed in 2010, but yielded a resolution that has continued to expand protections against police abuses into 2023. So this case was a constitutional challenge to racial profiling in the city's stop and frisk practices, filed on behalf of 8 Black and Latino Philadelphians who were stopped by the Philadelphia police based solely on their race. So it was filed in 2010. By 2011, the police department actually agreed to a resolution that was acceptable to us and our clients, whereby, among other things, the police submitted to monitoring by an independent court-appointed monitor. They launched a pilot program to eliminate stops in selected precincts based on, to stop stopping people based on certain low-level quality of life offenses, and began tracking and reporting data, including race-based data on police stops in the citywide. So that pilot program lasted several years, and this year we received some positive data as the pilot program was expanded to include all precincts in the city. So the net result should be to greatly reduce, if not eliminate, unwarranted stops for the particular low-level reasons that we started with in the pilot program. We received a quality of life audit update in July of 3 as part of the Bailey resolution. That shows that the city and the police department are improving, though that progress is slow and incremental. The overall number of stops are down, which is to be expected if the resolution is being complied with. But racial disparity in the stops that are happening is still too high. So far, the police department has continued to express a shared desire to keep improving, but the case remains pending so that we can keep monitoring compliance with the resolution and continued improvement on the numbers. We also continue to monitor the city's policies outside of the context of the Bailey case. So we've been pushing back through our advocacy efforts on rhetoric by the incoming administration about a return to stop and frisk, which obviously would be a violation of the Bailey resolution. And we recently opposed a proposed ordinance in the city of Philadelphia that would ban ski masks in public spaces. And part of our reason for opposing that is because the police department has indicated they will use such a ban as an excuse for unnecessary police encounters with BIPOC youth. So both within Bailey, where we've seen a lot of progress, and outside of that case, we've been doing a lot of work in the last year. The second major case development in the policing area is a police misconduct case we filed on behalf of a group of Black people victimized by police misconduct in Western Pennsylvania. We filed a complaint actually earlier this month with the goal of holding McKeesport Township and Allegheny County Police accountable for a lengthy abusive manhunt they carried out 3 years ago. So this goes back to December of 2020, when a young man in McKeesport was being arrested for violating a restraining order. And during the process of the arrest, he somehow got his hands on a gun, shot an officer, and fled. The officer was thankfully okay, but the McKeesport and Allegheny police departments immediately launched a manhunt that residents of a majority Black community in McKeesport later described as 8 days in hell. Of course, you would expect that police will mobilize and conduct a serious search for an armed suspect, maybe especially when a police shooting is involved. But we brought this suit for a couple of unique reasons. The first was the terribly abusive and discriminatory manner in which the police carried out their searches. So even something as serious as a police shooting does not suspend citizens' rights under the Fourth Amendment or give police the green light to apply excessive force. But what happened here is that the police pretty clearly targeted Black people in McKeesport, many of whom had no conceivable connection to the person they were looking for, barged into their homes, searched their cars at gunpoint with no warrants, no probable cause, manhandled citizens, their children, really for no reason. And at the same time, what our investigation revealed is that white residents, some of whom had direct connections to the suspect, his stepfather for one, his brother's girlfriend, were confronted with much more friendly knocks on their doors instead of guns and force. So that's one reason why we filed this action. The other is that the events of December 2020 happened in a broader context. And that's a broken relationship between police and the residents in McKeesport, where our community partners have reported that even aside from that week in 2020, residents feel like the police have been a constant occupying force. So we spent some time doing an investigation, and 2 weeks ago, filed claims in Allegheny County Court of Common Pleas alleging violations of the 4th and 14th Amendment, as well as their state counterparts in the Pennsylvania Constitution and several tort claims. And we expect to be litigating those claims in earnest in the next couple of months.
Thank you, Steve. I had my thing on mute, which is good because you didn't get to hear my comments on when you were describing that awful case there. But that is a good segue into some of the things that Ghadah's been doing. So Ghadah, why don't you tell us about what's been going on in Pittsburgh?
Great. Well, I mentioned before that we were successful in getting Pittsburgh Public Schools to issue a moratorium on summary citations, but I want to explain a little bit more about why that was so important and why our ongoing work in this area is so important. So summary citations look similar to a traffic ticket, and they're issued for very minor infractions, usually what we would consider typical youth behavior, often categorized as disorderly conduct. So that includes excessive noise, obscene gestures or language, or even for vaping. They aren't issued at the time of the offense or the behavior. They're sent in the mail. So it may take several weeks to arrive or not at all if the youth does not have stable housing. And although receiving a ticket seems like a minor issue, they're actually harmful and they can cause long-term consequences on youth. So for starters, they're adult criminal offenses. There's no distinction between juveniles or adults when it comes to citations as there are in arrests. With a citation, youth are required to appear before a magistrate. They're not provided legal counsel, so they may not understand what their rights are. There's also no minimum age for a citation as there is with an arrest. So we've seen citations issued across Pennsylvania to children as young as 5 years old. If a student fails to appear at the hearing for any reason, then they may be tried in absentia, and the trial could be conducted without their presence. And while they could appeal this within 30 days, they aren't offered legal counsel, so they may not know they can do this or even how. Summary citations typically result in fines that is completely at the discretion of the magistrate. And by the way, magistrates do not have to have a law degree or be a lawyer, just in case people did not know, but they can issue fines up to $300 in addition to court fees and costs. These fines can further escalate these minor infractions because if the youth or their families really are unable to pay these fines, they're charged separately with what's called a failure to comply charge, and it's automatically referred to juvenile justice. And in fact, failure to comply accounts for roughly 15 to 20% of all referrals to juvenile justice in Pennsylvania. So it's essentially a way of punishing poverty. Summary convictions are also not automatically expunged, and a record of the summary offense conviction cannot be expunged until 6 months after turning 18, and only if all conditions have been met. So if, like many youth at 17 or 18, they apply for a job, fill out a college or military application, and they're asked if they have ever been convicted of a crime, they must say yes, even if it was for obscene language or throwing a lollipop, which is actually a reason that a 10-year-old was issued a summary citation. Getting a record expunged typically requires the help of a lawyer, which also costs money. And if, for example, they have forgotten they had a summary citation issued because it happened when they were 8, and it's revealed in a background check, then they can lose that job or college opportunity. In terms of the statistics around this, so although the data isn't public, when we look at places like Pittsburgh Public Schools over the last decade, Black students accounted for between 80 to 89% of all citations issued, but they account for about 50% of the student population. Black students overall were 12 times more likely than white students to receive a citation, and Black girls in particular were 24 times more likely than white girls to receive a citation. And of course, Black boys with a disability are the most likely demographic to receive a citation. So all of these reasons are why we have been pushing for school districts to eliminate the use of summary citations as a form of school discipline. Another area that we've pushed for reform was in a letter we drafted to the State Board of Education. We made recommendations for revisions to the Pennsylvania Model Memorandum of Understanding between school districts and police, which all school districts in Pennsylvania are required to have. But to be clear, it doesn't mean that school districts are required to have police employed. So the letter we sent made recommendations to amend the language because it's led to confusion on the part of school district administrators and the unnecessary involvement of youth with law enforcement beyond what is legally required. So we urge the state board to, 1, clarify the police notification requirements by eliminating listing of infractions that were discretionary, incorporate federal education guidance and laws that places restrictions on when school districts can share student records with police, and explain the rights of students when interacting with police in a way that they understand, like to their age and ability. So yeah.
Thank you, Ghadah. That's great work in trying to disrupt the pathway that we're seeing for the juvenile justice system. Now, earlier, earlier I mentioned our priority issue areas and where we're spending our time. One of the emerging threats we've responded to this year has been defending LGBTQIA+ students. We've been working in the 4th largest school district in the state, along with others, on ensuring an inclusive educational experience for all kids. Steve, will you share how this work has shifted a bit this year and provide us an update on a case that we discussed last year when we did this session, the case coming out of Bucks County?
Sure, and you know, many folks in the audience will be pretty well acquainted with our efforts in the Central Bucks School District. It's been one of our more higher profile efforts in the last couple of years, and many of you know about our work in the last fiscal year when we helped marginalized LGBTQIA plus students submit a complaint to the U.S. Department of Education about the hostile school environment that had developed in that district. Coming into the current year, in addition to the DOE complaint, we took on an employment and defamation action against the district on behalf of a Central Bucks teacher who had been punished for essentially for being an ally to his LGBTQIA plus students. Anthony Burgess, who's a beloved teacher, was suspended in a pretty high profile move by the district in 2022. After he pointed impacted students to resources and was supportive in that very small way. And then, again, fast forwarding a little bit, after we filed our DOE complaint, when the district conducted an internal investigation, at the conclusion of that investigation earlier this year, it became clear that the district and its lawyers had used their internal investigation as an excuse to vilify Mr. Burgess and really lay a lot of the blame for the strife in the district at his feet. The district publicly posted a harmful and misleading report from its counsel and also imposed further discipline on him for imagined failures to comply with policies that weren't actually in place before the investigation started. So again, we mobilized, filed a federal employment and defamation action against the district on behalf of Mr. Burgess, and we've been in a dogfight with the district in that civil action for much of the past year, while the DOE separately continues its investigation into the district based on our initial administrative complaint. While we're in that fight, our public campaign around the harmful conduct in this district and others has actually had an impact. In November, the community in Central Bucks actually voted overwhelmingly to change the composition of the board to one that is now, or we at least expect to be, much more inclusive and welcoming to LGBTQIA plus community members. You know, we continue to litigate the case with the district over Mr. Burgess's discipline, but we're cautiously optimistic about the future for students in this district now that new board members are in place. And then I'll also add, outside of Central Bucks, you know, our advocacy efforts weren't limited to that district. There are several others with boards that have been following a very similar playbook, including Perkiomen Valley, Penridge, just to name a couple. And in those districts as well, the November election changed the landscape and the membership in those boards to make them their composition hopefully more inclusive-minded going forward. That didn't happen everywhere, right? So it might have the election might have released some pressure in particular districts in the short term, but we continue to monitor other places where harmful policies like anti-trans bathroom policies are either going to stay in place or you know, some new boards are going to be considering them anew. So we've got our eyes out and our antenna up, and I think what you'll see in the coming years that we shift more into state court and look to develop anti-discrimination protections under state law in Pennsylvania.
Thank you, Steve. Ghadah, I know you have something to report on this topic as well.
Yeah, so in relation not just to Central Bucks, but also to districts really across Pennsylvania and across the nation, surveillance technology. So things like GoGuardian and Gaggle have become increasingly popular with school districts as these companies tout their software as a way to alert districts about students in crisis, to improve student safety, even though there's been no evidence that they actually work in that way. In terms of what it does, it's installed on school-issued devices. It monitors students' emails and social media posts, even when they're written from home or not about school. It can even monitor cell phone texts and images if the cell phone is plugged in to the computer. And because the algorithms used don't detect context, but rather pre-programmed words, much of what's flagged as suspicious or a threat is later determined not to be. But this is after students have been interrogated by police, which can have devastating effect on students who are accused of, being threatening or a harm to others. So as school districts like Central, Bucks, and across the nation embrace these, most of them are failing to consider things like student privacy. Who has access to the data being collected by the surveillance technology? What is the data being used for? What type of data about students is being collected and shared? And additionally, do school districts understand the unequal impact surveillance has had on students, particularly for low-income students who have to use these device-issued laptops, Black students, and LGBTQ youth in particular, because many have been outed by this technology. And parents are often unaware that this type of surveillance is being used, as districts don't require parents to opt in. So far, we've been successful in stopping this in places like Pittsburgh Public Schools, but it's been much harder to get it out of school districts that have already purchased it. One thing that we have continued to say, which is kind of feeds into what Steve was saying about a more supportive environment, is that it really doesn't matter how much surveillance or AI you have. Nothing is going to protect students or staff if you're not putting in the work to make a healthy, safe, and supportive environment. There is no technology that replaces that.
Great point. Thank you so much. And I see that there's some great questions that are coming in, and we will definitely hope to get to all of them, even though I know there's been some that have come in response to things that have been said so far, but don't worry, we will come back to them for sure. All right, shifting gears just a little bit, the ACLU of Pennsylvania is committed to ensuring that all eligible citizens can register to vote, cast their votes, and have them accurately counted. We've been working hard this year on protecting those rights, ensuring access, working to eliminate barriers, and increasing civic engagement. Marian, we are fortunate to have you join our team and take this work head on, and you've had your work cut out for you. Since the 2020 election, the institutions of our democracy and our democratic processes have been under attack. So, Marian, what significant cases and advocacy did the ACLU of Pennsylvania work on this past year?
Well, thanks, Riley. So we, in our voting rights work, is done in coalition with a large number of nonprofit groups. We work in coalition to prevent voter disenfranchisement. We support our coalition partners in voter registration, and we are currently planning very heavily to prevent election sabotage in the 2024 election. But I'm going to talk about our litigation because I've been in the voting space for quite a long time, and I've never seen the amount of litigation that has remained constant since the presidential. So the most of the litigation has centered around Act 77, which brought Pennsylvania the no excuse mail balloting. And it's been our plan and our goal to try to get as much clarity around that law as possible in advance of the 2024 election. So we already talked about the one case on provisional ballots, which definitely needed clarifying. And although it's a district court case, we found that the court's opinion was persuasive for a lot of our counties. But I'm going to talk at length about our current litigation, NAACP against Schmidt, which is a federal case that we filed it in the Western District of Pennsylvania in Erie to challenge Pennsylvania's mandatory date requirement under the election code. Yeah, sorry, I don't know how to mute this computer, and I'm getting G-chatted, but in any event, Pennsylvania election code requires voters to fill out, date, and sign the declaration on their mail ballot envelope. There has been an enormous amount of litigation trying to throw out ballots because there were disqualifying defects on that declaration. And the NAACP case is a direct result of these attempts to disenfranchise voters. But the first case that addressed this legal issue of what that language in the election code meant was In Re Canvass of Absentee Ballots in the 2020 general election. And that is a case where the Pennsylvania Supreme Court fractured 3-1-3 on the issue of whether the election code's requirement was mandatory. 3 justices said no, that it wasn't mandatory, it was directory, and the ballot should count. And 3 justices said yes, it was mandatory, and the ballot should not count. But Justice Wecht concurred in the result that the ballot should count, but what he said was that the Pennsylvania Supreme Court must give statutes their plain, ordinary meaning when possible, and that they shouldn't contort themselves to come up with a outcome determinative result. So even though he believes that the word shall fill out, date, and sign the declaration is mandatory, he said in the 2020 election, we will count the ballots because voters didn't have notice that this was going to be the impact of their error. So what followed was a series of cases trying to figure out what the 3-1-3 decision meant. And the one that started us down the path with the NAACP case arose out of the 2021 municipal election in Lehigh County. In that case, as you know, we elect judges. In the judicial election, there was 2 candidates for the last seat on the Court of Common Pleas were separated by 70, I think it was like 70 or 75 votes, but there were 257 mail ballots that had a defect on the envelope. And so the candidate that was ahead sought relief in state court to prevent the Board of Elections from counting those ballots. They got up to the Commonwealth Court. Commonwealth Court said, no, those ballots cannot be counted under our reading of the election code. The discretionary appeal, the petition for allowance of appeal to the Pennsylvania Supreme Court was denied, which everybody was surprised. And so that's when the ACLU filed suit in federal court under the materiality provision of the Civil Rights Act of 1964. That was the Migliore case. That all happened in 2022. We litigated that up. We got a great opinion in the Third Circuit. It was 3-0 with a concurring vote yes by a Trump appointee. And in their holding, let me just say one other thing. The material, let me see. Sorry. The materiality provision provides that it prohibits any person acting under color of law from denying the right of any individual to vote in any election because of an error or omission, if such error or omission is not material in determining whether such voter is qualified to vote in such election. But it also relates only to paperwork errors, and it has to be an act that's requisite to voting. So, what the Third Circuit held in Migliore was ignoring ballots because the outer envelope was undated, even though the ballot was indisputably received before the deadline for voting, serves no purpose other than disenfranchising qualified voters. This is exactly the type of disenfranchisement that Congress sought to prevent, and I'm quoting from the opinion. Well, because of that order, Lehigh County was directed to open the ballots and count them, and the result of the election changed. Fast forward to October of 2022, when the RNC filed a case in the Pennsylvania Supreme Court invoking their King's Bench authority. The court held that 3-1-3 fractured decision was actually precedential, and that they were bound by the holding that shall fill out, date, and sign was mandatory, and the ballots could not be counted. But because of Justice Baer's death, they deadlocked on the materiality provision. That's when within days of that decision, the ACLU Pennsylvania and our National Voting Rights Project filed the NAACP case. Now, I'll just give you a brief status of that case because it is currently on appeal in the Third Circuit. On November 21st of this year, the district court ruled in our favor on summary judgment and held that but we had asked for two types of relief: preliminary injunctive relief to count the 2022 ballots, because we had our plaintiffs were organizational plaintiffs who had expended time, effort, and money to educate voters and prevent disenfranchisement, and individual voters whose ballots were actually not counted. So we got an order that injunctive relief against 12 counties, that they had to count ballots in 2022, and we got a declaratory judgment declaring that enforcement of Pennsylvania's date requirement violated the materiality provision of the Civil Rights Act of 1964. So we've been skirmishing now for the last 2 weeks in the district court and in the Third Circuit, but the Third Circuit has issued a stay. I don't know exactly what that means, because the election they've all been certified, so they can stay the order, but all the ballots have been counted, all the results have been certified. There was a so-called emergency because of a township supervisor race in Talmenson Township, Montgomery County. The candidate who ended up losing is able to intervene. The good news is the case will be on an expedited appeal in the Third Circuit, and we've avoided the Supreme Court shadow docket for now. But I'm going to close here because there's not enough time to really talk about all of our voting rights cases. But thank you, Riley.
Thank you, Marian. And there may be a chance to expound on some of that during the question and answer session. Ghadah, I know that you had something on the voting issues as well.
Just briefly, wanted to highlight the importance of local elections, especially school board races. As Steve highlighted, there was a shift in central Bucks, and so the environment will likely change. But school boards determine the code of conduct, the dress code. They create policies around school discipline and safety. They make decisions on hiring police or creating their own police force. So not enough people tend to vote in those elections, but they are very important to our day-to-day lives.
Well, thank you. So before we open it up to for questions, and I know that there's a few coming in, I do want to talk about looking ahead, and some of these answers I think will even come out answers to the questions. But Ghadah, what are you planning on and envisioning coming down the pipe for 2024?
Well, I think there's a lot that's planned for 2024, but in short, I'm just going to highlight 3. So to start, we'll be working with Steve and Professor Kara McClellan from the Advocacy for Racial and Civil Justice Clinic at UPenn to do research and community outreach on the use of citations as a form of racialized discipline. From some of the data that we've been able to obtain, it seems clear that citations tend to target Black students, including Black students with disabilities. So we're working on a way to change this harmful policy and secure a formal ban on this at Pittsburgh Public Schools initially, before potentially moving on to other school districts. This past election, we saw a lot of new school board members take office. So we've been working on creating a toolkit for new school board members to highlight best practices, provide example of policies that help rather than exclude students. And then I talked about getting the data from AOPC. So we will be releasing the data we collected on summary citations after we've had a chance to thoroughly analyze it and document any trends or disparities.
Great, thank you. And Marian, what about on the election? Obviously, you know that there's a lot that's still hanging out there. So what do you see coming up for the election cycle for 2024?
Well, we're going to be focusing on so many different areas, but some of the most important things that we'll be doing in coalition will be planning to prevent any kind of election sabotage. And it's a really multidisciplinary effort that involves not only legal, but advocacy, comms, mobilization. We'll be still litigating the appeal in the NAACP case. I also want to mention we've got a response to a right to know request that we submitted to the Department of State on voter registration applications and also on list maintenance. Want to make sure that people who register to vote actually get on the rolls, and we're going to be doing a deep dive and analysis to make sure that Black and brown voters are not being discriminated against and not having their applications accepted or approved, and not being disproportionately removed from the rolls. we really are going to be taking steps to ensure that our institutions of democracy continue despite so many assaults against them.
Thank you, Marian. All right, I want to turn to our questions, and I know we have a host of them. I'm going to take them kind of in different orders. And this kind of aligns with, I think, with what we were just talking about. So I want to go over to Steve. And Steve just asked you, one of the questions came in, what, as you look forward to 2024, what issues are you most concerned about?
Yeah, I will, thing I have at the top of my list, I will not spend a lot of time on because it would steal thunder from Marian, but I think in 2024, voting rights are paramount, right? And so we work in a lot of different issue areas that you outlined, Riley, and then some. But in 2024, I think we'll see the full weight of the legal department behind voting rights work to make sure, as Marian said, that that we protect the franchise at a time when it's most in peril. Aside from that, I would go back to criminal legal reform. We're in a moment where the tough on crime rhetoric has ramped up in Philadelphia, in Pittsburgh, and elsewhere. And if past is prelude, and if we're not careful, that rhetoric of fear can turn into ignorance of a lot of people's constitutional rights, and usually Black and brown communities are first in line to have their constitutional rights restricted by police and in the criminal legal system. So, you know, I think we'll remain focused on those priority areas in 2024 and look for ways to push back both in advocacy and in the courtroom, ways to push back on efforts to use rhetoric of fear as an excuse to ignore constitutional rights.
Thanks, Steve. A question that came in at the top was, has the ACLU taken a position on HHS policies on U.S. pharmacy chains providing access to U.S. citizens' prescription medication records without a warrant? Is there anyone that could chime in on that? I think Sarah? Or maybe I got that wrong.
I think the quick answer is that the ACLU of Pennsylvania has not taken a position on this. So I'll stick my neck out and say that, but because we haven't taken a position, I don't know how much more I can say.
Got it. Thank you, Steve. For a general question that I think is very helpful, someone asked, how can individual attorneys, solo versus firms, support the great work that we do? How have you seen, God, I want to go to you. How have you seen solo attorneys and or firms get involved? And if so, how do they go about doing it?
I mean, they could probably help. At least I know in Allegheny County. So our juvenile, the public defender's office, the juvenile division, has been taking cases where youth have been issued a summary citation and going to the magistrate with them. And so that's one way, is by, you know, volunteering to help youth who have been issued a summary citation, because again, they're not provided a lawyer. So that's one way. I think that would be very beneficial.
Thank you. Steve or Marian, any other inputs on getting lawyer? Go ahead, Marian.
Yeah, so one thing that we do as we're part of the National Coalition, the Election Protection Coalition, which is a nationwide effort that is really focused on the few weeks before election and on election day to help voters who are experiencing problems voting in real time. And one of the things that the ACLU bottom lines for the coalition is having attorneys available to go into court on election day. And we do our best to recruit attorneys in all 67 counties. I'd say we have more than half. We usually end up with more than half. But if people are interested in that kind of work, you just have to be available to be on call, and if you have to go to court. The other thing that we're going to be doing this year, which we started in 2022, is monitoring post-election processes, the post-election canvas in the counties, because if there's going to be shenanigans, in some of these counties, we want people to be there and to be our eyes and ears on the ground. And so we get early notice because as we know, there's a 48-hour appeal deadline. So the earlier we know that things are going to go awry, the better. So that's one way that solo and I think it was solo and small firm attorneys can help.
Thank you, Marian. Now, for the audience, I promised you 2 passwords, and I'm going to give you the second one now. The second password is racial justice. Racial justice. So be sure to mark that down for your CLE credits in all caps, racial justice. Okay, another question came in regarding, I'm going to go to you, Ghadah, on marijuana possession. It says, any comment on the new Allegheny County report about much higher criminal charges filed against Blacks, including the police not following the law to file citations rather than charges for marijuana possession?
I'm not a lawyer, so I don't know if it is a requirement, but I will say that I specifically asked Pittsburgh City Police about this because as I was reviewing the data for adults, not just for youth, I saw that some were being issued a citation and others were being arrested. And the answer that I got from local police was that it was not required. It was merely a recommendation, and it was up to the discretion of each individual police officer what to do.
Got it. Thank you. And Ghadah, while I have you, let me ask you a question that came in. The questioner was wondering if you or anyone else has seen the summary dispositions negatively affect immigrant youth because they count as convictions and can affect even legal immigration status.
Yes, that has been an issue. Yes, in terms of either deportation or in terms of getting citizenship, even for the families, not necessarily just for the student.
Got it. Thank you. This is a question that the questioner put in on wanting to know whether or not some prior work we done had actually had any effect. So the questioner says, several years ago, there was an ACLU lawsuit in a Philly suburban county to force the court there to consolidate court costs when multiple cases against one defendant were involved. Recently, the questioner noted that 2 cost sheets in one case that that the questioner was aware of had turned into only one in the several years since he had last looked, and the amount had been cut in half. Is there a relationship? Does anyone know whether or not any of the prior work that was done may have resulted in this? Go ahead, Steve.
Yeah, I can't speak to that particular the particular facts that the questioner posted, but I can say that the work on addressing burdensome court debt costs, fines, fees, and restitution has been ongoing and has resulted in a lot of great incremental progress, including during 2023. And I mean, I think we don't have enough time left to go through all that work, but I will recommend that folks check out our website. There's a great debtor's prison landing page on our website that goes through the latest and greatest information and developments on ways in which we've tried to minimize the impact that court debt has on people and keeping them hung up in the system. And one of the great recent developments, actually it's been a couple of developments along the same thread, which is to confirm that courts have the ability and the discretion at sentencing to waive certain forms of court debt so that they do not become the albatross they too often do become for poor folks that end up stuck in the system longer than, long after they've paid their debt in terms of time incarcerated.
And I think we may have time for one more question. So there was a question on, has the ACLU of Pennsylvania done any work on freedom of speech this year? Steve, can you answer that?
Sure. The short answer is a ton, yes. And a lot of the work that we do supporting freedom of speech never sees a courtroom because many of the intakes that I talked about earlier in this program are on free speech issues, and many of those issues tend to be pretty clear cut. So government entities will stand down when the ACLU writes them a letter or calls them. So we spend a lot of time on things that nobody ever sees to make sure that people's free speech rights are vindicated. Some of the stuff that has seen a courtroom over the past year, we have a couple of student speech cases. One where we got a win on behalf of students who wanted to open an after-school Satan club in I think it was the Saucon Valley School District. And the school was not letting that happen. And whatever you feel about a club called the After School Satan Club, it's unconstitutional not to let them have the same status as other clubs, including, in some public schools, they have religious affiliated clubs. So we were able to get an injunction from a federal court to let that club establish itself. A few weeks ago, we filed a lawsuit involving another club in the Twin Valley School District, the Retire the Raider Club, which is focused on advocacy to try to change the school district's racist indigenous mascot, and the school has gotten in the way of giving that club full recognition. We just filed a lawsuit a few weeks ago in federal court to try to get an injunction to allow that club to operate just as any other club. And then on an ongoing basis, we some other work that hasn't seen a courtroom in a while is just our assistance of folks who are demonstrating in public spaces and protesting. We are very often just kind of plugged in to what's happening on the streets during organized protests, interacting with police on the ground and trying to make sure that people are able to have their voices heard without undue restriction.
Thank you, Steve. I know that we're right at the end of time, but there's only a couple of questions left. So let's see if we can just get through those. Actually, just one. Do you have concerns about the current Supreme Court if and when your litigation reaches it?
I had wanted to give an answer to that. I mean, of course we do, right? The court has swung so far to the right, but in the voting case that has the potential to go to the Supreme Court, it's not clear. It's it's a petition for cert, so it's not clear that they would take it. If there's there might be a circuit split on the materiality provision, which would make it more likely that they would take it. But I will say that in 2022, in the Migliore case, they after the Third Circuit ruled unanimously that the enforcement of the date requirement violated the materiality provision, the opponents went up quickly, tried to get a stay pending appeal from the U.S. Supreme Court, and it was denied 6-3. It was Alito, I think it was Alito, Thomas, and Steve, who was the third? Gorsuch in the three.
I think that's right.
And Alito wrote a dissent, which they keep citing as some kind of authority, but it is a dissent. But so they didn't get the stay, and the case was certified. But then what they did was run back up on a petition for cert to have the decision, the Third Circuit decision, vacated under Munsingware. And basically what that principle is that if events cause the case to become moot through no fault of the litigants, then the case can be vacated. And so the Supreme Court did vacate the Migliore decision. It only binds the parties to that particular dispute and is no longer precedential. We don't have that issue in the NAACP case because it didn't depend on certification, which was one of our strategic decisions in the way we filed it and the way we framed it. So short answer, yes. Long answer, maybe we won't have as much a problem, but we'll have to see.
Thank you, Marian. I know that there was one other question regarding the ski mask in Philadelphia. I'm sorry we didn't get the answer to that. I will say, though, I don't know how the individual council members voted on that, but I would say that, regardless of their race, it could still have a racial impact and be racially motivated, despite how they voted. With that, thank you for all those great questions, and thanks again to our staff panelists and all those in attendance. I really appreciate it. I really enjoyed hosting this as well. So thank you for giving me the opportunity to do it. A huge thank you to Jackie Rosen, who kept us all organized and running the tech behind the scenes and kept me on point. And last but not least, a special thanks to Fagery Drinker for sponsoring today's CLE. You'll see a link to the survey in the chat. It's going to be coming up, and we'll be sending it in a follow-up email as well. So look out for that. And if you enjoyed today's discussion and are able to consider a gift to the ACLU of Pennsylvania today, please visit www.aclu-pa.org/donate to make a donation and check out the various ways to get involved. And with that, we will end the call for today. Happy holidays and thanks to everyone, and be well.